Good morning, everyone. Welcome to Law Sessions. My name is Samuel Senyonjo. I'm going to be taking you through the law contract, and most specifically today, I'm going to be talking about offer. We introduced the law of contract, and today I'm going to be taking you through offer. Sorry, yesterday we had some problems and we didn't make it, but today we are going to be talking about offer. What is offer? I'm going to talk about what is offer. I'm going to talk about rules of offer. I'm going to be talking about the types of offer. If time allows us, I'm going to be talking about communication of offer, acceptance of offer, and determination of offer. So today we are doing the law of contract. But before we do the law of contract, I want to talk about what we call case under case law, because today we are going to do something to do with case law. So last time I explained what case law means, but now there are some things we do add on. Each and every case that is decided, it is reported in a certain year and in a certain report. So we have reports. Like, for example, let me give an example. In Uganda, we have what we call Uganda Law Report. We have Kampala Law Report. So after deciding the case, that case is being put in a certain report. So the year is reported, the parties are reported. First of all, the parties, that is, as I told you, we have the parties, Samuel Senyonjo versus Kisache Joanita. Na 2020 Uganda Law Report, say at page this, say at page this. So today I'm incorporating in another thing, and that is called law reporting. So I'm going to be giving cases under report. Then today I'm also going to introduce something we call general rule in law. In law we have what we call a general rule. That is the rule. The rule of the thumb is. The general rule is. And now the general rule has what we call exceptions. So today I'm introducing the cases, and then I'm introducing something to do with general rule. Well, I'm going to do offer today. What is an offer? An offer is a promise. I promise you something. It is like a promise. An offer is defined in our act, the Contracts Act, Cap 2020. And let me define it here. Mean is the willingness to do or abstain from doing anything signified by a person to another with a view to obtaining the assent of that other person to the act or abstinence. That is section 2A, 2C of the Contracts Act. So an offer is like a promise. It's like a promise. So I want to engage you to do something. I give you a promise. I want to take you. I want to do this. I offer you to buy this. So it is like either I need a promise back or I need an action. That is what we call an offer. I offer you that, yes. Would you marry me? That is an offer. So it is a promise. You may say I'll marry you or not. It is an offer. Or I bring my car. Will you buy this car? So that is an offer. That is a promise. So in contract, we do have what we call offer. We can never have any contract without offer. So we have offer before we have any contract. After all, what are you going to contract about if you do not have an offer? So like a car, I offer to you to buy my car. I offer you. I'm selling you my car. That is called an offer. Today I'm going to be talking about an offer, a promise. A promise. So either it is a promise, like I was telling you the other time, bilateral and unilateral. It is either a promise to a promise or a promise to an action. So, or a promise to an action. And today, that is what we're going to discuss. One, that is the definition of an offer. And two, I'm going to talk about the types of offer. Three, I'm going to talk about the rules that govern offer. Law of contract is very live. It is very, very live. It is every day we do contract. Every day we do contract. Every day. Every hour we do contract. The Uber guy, that is a contract. The restaurant where you go, that is a contract. the hospital where you go, that is a contract. In case they breach a contract, you're going to take them to courts of law for damages. So now you need to understand what is the law of contract. It is very essential. It is very crucial. We do it every day. Like last time I was telling you, like some people who are in the diaspora, it is a contract you made from day one to where you are, even where you're working. That is a contract. So that is why you need to know the law of contract. You need to know your rights. You need to know the duties. Now, let's go to the types of the classifications of an offer. So we have basically there are like 7 types of contract of offer. Number 1, we have what we call a specific offer. What is a specific offer? Specific offer happens where the person offering is offering to either a person known to that person or a general public, but it is specific that I'm offering you to buy this. I'm offering you to buy this. The group of persons or person is specific. It is not in quotation, so it is called a specific offer. It is that offer is accepted to a certain person. Like, let me use this social kind of offer. Will you marry me? It is not to the general world. It is specific to you, the one I'm offering to. So that types of offers. 1, we have specific offer. I'm offering it to a certain person or certain group of persons. It is specific. That is number 1. And there is what you call general offer. It is the opposite of specific. General offer, I'm offering to the whole world. Like, for example, I may say, I've lost my dog, and I'm offering that anybody who finds my dog, I'm going to offer them 10,000 or 100,000 Ugandan shilling. That is not a specific offer. It is a general offer. It is offered to the whole world. So anybody who finds my dog and they have heard about the offer, they will come and claim the damages, all the money. They will come and claim actually the money. So it is not specific, it is general. So you have specific and the opposite is general. It is offered to the whole world. It is offered to the whole world, and any person who wishes to fulfill the conditions are put may take up that offer. We have what we call counter offer. Counter offer, you're going to read the case of Hyde versus Rich. Like I've told you, today we are going to do something to do with cases. Hyde versus Rich. It is 1840 case. Hyde versus Rich. It is Hyde versus WRENCH. It is 1840 case. So if I offer you something that I'm selling this car, and you tell me that you want maybe some modifications to that car, that is a cross offer. In other words, you've refused my offer and you are offering something else. It is called a cross offer. I'm offering you something, but again, you want some modifications in the thing I'm offering you. So you, the offeree, because you have the offerer, me who is offering, and then you have the offeree, you, I'm offering the thing to, or the property to, or the subject matter. So if I offered you something and you want some changes, you want some modifications, that is a cross offer. I've offered you something, but you want some changes. Yes, I want that phone, but can you make it like this? That means you've refused my offer, and actually you are offering to me. In other words, now you are the offerer. The offerer is the person who offers the subject matter. So you are now the offerer. Another type, we have what we call cross offer. What is a cross offer? That case of Hyde versus Rich, you read cross offer. What is a cross offer? A cross offer, like for example, I have a property. I have a property, I want to sell it to you. Unknowingly to me, you also wanted to buy the same property, probably even at the same price. Like you are offering $100. I wanted to sell it at $100. But you don't know that I'm offering it. You are not aware. You are not aware that I'm offering it. That one is called a cross offer. Still, it doesn't amount to an offer. It doesn't amount to a specific offer. Why? Because the minds have not met. We call it consensus ad idem. There is no consensus ad idem. Yes, you wanted to buy it. I wanted to sell it, even at the same price. But then, we never met like in the mind. You have a different view. I had a different one. So, it is called a cross offer. That means we have to come on the same table to do the contract, to do the offer. It is not a specific offer. Even if you want to buy it, even at the same price, but there is no meeting of mind. There is no that meeting of mind. Consensus ad idem. Now, that is cross offer. Another one, it is called a standing, all open, all continuing offer. Standing, open, all continuing offer. It remains open for a specific period of time. Like, companies, they may say, we want person to supply us with this, maybe a certain raw material. That thing remains open. It is called standing, all open, all continuing offer. It remains open for a certain period of time. So anybody can offer to supply the raw materials. That one is called standing. We have what we call express offer. Express offer, from the word express, as I explained earlier on in the last series. Express is something deposited. It is something, it may be deposited or written down, or I tell you orally. This offer, like it is maybe written somewhere, or I tell you orally that I have this, or I'm selling this. Are you going to buy it? So it is called express. That is a type also, something that is written down, or I come to you that I'm selling this, I'm offering this. Will you buy? That is called express offer. Another example, a type is implied. Implied is the opposite of express. Something implied, it is either implied by customs or by conduct. For example, we are Ugandans, those stages we have in Uganda for taxis. That is an implied offer. They are offering to take a certain person from a certain distance to another. You know very well that maybe from Kampala to Entebbe is 60,000. So it is implied by custom, by conduct. I'm sure we are getting it. So it is implied. There are some implied offers. Let me use the example, still the social example of relationships. You people, you have ever gone to school, or even if you've never gone to school, but you know these things of crush. You see that this guy here is interested in you. Maybe you are also interested in them. He's interested in you. Maybe you are also interested in them. They never come to you to tell that, hey, we love you. But impliedly, you are seeing it. This guy wants to take a move. Maybe if he has, but he wants to take a move. He has a crush on me. So that is something implied. It is not express. They have not come to you to tell you, but they have a certain offer. So, implied offer is that offer by custom, by conduct, by circumstances, like this weighing machine or weighing machine. It can be another example. It is implied. It is not express. But if you go there where there is that weighing machine, you stand on it, it is implied offer. You have to pay back. You have to pay them. It is not express. It is not anywhere. It is not written. They have not called you, but it is implied. Those are the seven. Those are the seven types of offer. I said offer is a promise. A promise may be replied by a promise or an action. Bilateral promise or offer is two-sided, or bilateral contract is two-sided. I give you a promise, you give me a promise. You're going to do, like, for example, you marry me, yes. You can either say, yes, I'll marry you, give me that promise. So, there is bilateral. Like, for example, that one over dog, it is a unilateral. I tell you, I've lost my dog, I need it. If you find it, if anyone finds it, I'm going to give them this certain amount. It is unilateral. I've given you a promise of giving you 10,000 or 100,000, and you do not need to promise me that I'm going to bring the dog back to you. No, you just need to do the action. You just need to find my dog, get it to me, I give you the promise, I give you the money. So, those are the types of offer. Another thing I want to look at, I'm going to look at the rules governing offer. We have many of them, rules that do govern offer. Law has rules. Everything has rules. It has general rules and exceptions, as I've told you. We are going to see the general rules. We are going to see the rules. In law, you're not going to avoid what we call rules that govern this. Rules that govern this. The general rule is this, but the exceptions are these. So, you're not going to avoid that. 2, you're not going to avoid the cases. We read cases. You're not going to avoid it. And I will encourage you to read at least a certain case a day when you need to appreciate the law. It is so interesting. It is so interesting. You appreciate. So I'm now doing the rules governing offer. 1, offer may be made orally or in writing. So an offer may be made orally or in writing. Yes, that is a rule. I can tell you I'm selling my car orally, or I can put it down, I can write it down. So it can be made. Susan, rules, put L-U-L-E, that govern offer, and put number 1, offer can be made orally or written. It can be written or orally. That is number 1. Another thing, it must be firm and final, not an invitation to make negotiations. So if I'm offering anything, it must be final. It must be firm and final, not like inviting you to do the negotiations. There are some persons, they are indecisive, so they are selling the car, but they are not selling. They are as if they want to bring you on the table to do the negotiations. Then that is not an offer. It is something else. I don't know how they call it. Then offer must be capable of creating legal relations. Offer must be capable of creating legal relations. If you don't want to be legally liable, then that is not an offer. Any offer, and that is why these social things of will you marry me and I don't marry you, you cannot take me to courts of law to enforce that. Why? Because it is incapable of creating legal relations. We shall study family law and we shall talk about that. There are things very interesting. So, it must be capable of creating legal relations. Like will you marry me cannot create legal relations. Because why? If I don't marry you, you're not going to take me to courts of law to enforce that, because they cannot enforce relationship. They cannot enforce relationship. So that cannot amount to an offer. Another thing, offer must be communicated to the offeree. You are going to read from section 3, section 4, section 3, section 4 of the Contracts Act Cap 2020. It talks about communication. You need to communicate to me. You, the offerer, you need to communicate to the offeree. It has to be communicated. It can also be communicated to, yes, they're all public, but it has to be communicated. If the offer is not communicated, then it is not an offer at all. So 2 identical offers cannot amount to an offer. Yes, I talked about that, the cross offer. Two. They are two. They are identical, but they cannot amount to what we call an offer. Yes, I gave an example. I'm saying my property at 100,000 100 US dollars. You also wanted to buy the same property at 100 US dollars. But you've not talked to me, I've not talked to you. Yes, we have identical offer, but we don't know. I mean, you don't know that I have the same. I don't know that you have the same offer. So that cannot amount to an offer. Cross offer does not amount to an offer. An offer can be made to one individual, which is another point. An offer can be made to one individual or to the general public. It can be made to one individual or to the general public, like I've told you that thing of a dog. Yes, still it is an offer. If I told you I lost my dog, I want it back, then it is an offer made to the whole world. So, but this only person who does the act then can get the fruits of my promise. Last time I left the case behind, and that is the case of Khalil versus Smokeball Company. It is a case of 1893. What happened in this case? Let me discuss this case because it is crucial. It is very crucial. It is the locus classicus case in law of contract. At least every person knows about Khalil versus Smokeball Company. It is a case of 1893. What happened in this case? During that period, there was influenza in Europe, a lot of influenza. So this company, Smokeball Company, came up with that medicine, that drug called Smokeball. And they said that, they advertised and said that any person who contracted influenza after using our Smokeball, we are going to reward that person 100 pounds. By then 100 pounds, that was a lot of money. So they said any person who contracted influenza after using Smokeball, we are going to offer 100 pounds. They went on to deposit one effect. So now, this lady, this man Khalil, the plaintiff Khalil, consumed their medicine and again contracted influenza. So the plaintiff brought the case against Smokeball Company, demanding for 100 pounds as they had promised. So the argument of the company was that, no, you cannot offer to the whole world. That was an invitation to treat. Invitation to treat is like, I'm inviting you so that we can make an offer. I'm inviting you to trade. Treat is the same as trade. So the company was arguing that this is an invitation to treat. It is not an offer because, an invitation to treat is different from an offer. So this was the ruling of the court. The court ruled that the act of you depositing 1,000 pounds, one. Number two, the promise, the act of you depositing 1,000, it was another step. It was not only a path, but an offer. And then they went on to tell the company to hold that, one, an offer can be made to the whole world, but accepted by that person who works on the promise. Like a unilateral offer or promise versus an action. If I do the action, then I'm entitled to the promise. Like this person who finds my dog that has gotten lost, if they bring the dog to me, I cannot say, no, look here, I cannot offer to the whole world. No, I gave the promise, and this particular person has done the promise. has done the action, and then they are entitled to the fruits of the promise. So it was held in the favor of the plaintiff Khalil that the company was liable to pay the £100. So that is the case of Khalil versus Smokeball Company. It is a case of 1893. We have all the cases. So the case of Khalil versus Smokeball is to the effect that unilateral contracts do not need promise, do not need acceptance. I don't need to accept it. The mere fact that I perform what you told me, the mere fact that I perform the conditions, then if I perform the conditions, then it is done. Wow. The case of Khalil versus Smokeball Company, I was discussing something to do with that an offer can be made to the whole world. Let me give an example still that you understand better. If my dog got lost, I can offer that any person who finds my dog, I'm going to pay. But after this person bringing my dog, then I start saying that no, I cannot offer to the whole world. It is impossible. I have to offer to a certain individual. Then this person who has found my dog they went to courts of law. So this was the holding that Samuel, you lost your dog, you put 100,000. You say that any person who finds that dog, you are going to pay them. You even went ahead to deposit some money in the bank. That was not a path. That was not a mere invitation to treat, but it was a contract. It was an offer itself. So that is the case of Khalil versus Smokeball Company. Thank you, Ndagire. Must be communicated to the offeree. Another rule of offer that it must be communicated to the offeree. Remember, the offerer is the person who offers, who, if I may put it this way, who has the subject matter. And the offeree is the other person who accepts the offer or the promise. So I'm saying the offer must be communicated to the offeree. The offer must be communicated to the offeree. If you don't know about my offer and you go on and perform a certain act, like that example of a dog, we have actually a case of Fitch versus Sidakada. I gave you two cases last week, Khalil versus Smokeball Company, and I gave you this case of Fitch versus Sinadak. Fitch, I gave you, the spelling is F-I-T-C-H versus S-N-A-D-A-K-A-R. That is Sinadaka. What happened in this case? This is a United States case. United States FBI or police announced a certain criminal, that any person who could find that criminal and apprehend the same was to be awarded $200. So this person who never heard about the offer apprehended the criminal. The same took that person to police. So thereafter, this person got to know that actually police had put a certain offer for that same criminal. So he went to courts of law to demand for the $200. The courts of law had a very interesting holding. They heard that since you never knew about the offer, you cannot demand for the $200. So if you don't know about the offer or about my offer about the dog, you cannot claim. Why? Because you never knew the offer. It has to be communicated to the offeree. So if you don't know about it, please forget. That is number 7. Rules. That is number 7. Number 8. Offer must be lawful. I discussed this, but if I may briefly discuss it, it must be lawful. If you offered me marijuana, you want to sell me marijuana or Cuba, those things, that thing is illegal. Or even prostitution. If you offered me to give me sex, that is something illegal. That offer is illegal in Uganda. It is not enforceable. You cannot take me to courts of law. It is not binding to me. It is not binding. So that is not an offer. So any offer must be legal. If you are a prostitute and you offered that, maybe they never gave you the money, you cannot go to courts of law. Why? Because the contract was illegal. The offer was illegal. That is another rule. It has to be lawful. Another thing, an offer must be differentiated from an invitation to treat. An offer must be differentiated from an invitation to treat. I said earlier on that an invitation to treat is an invitation to trade. I'm inviting you so that we may trade. I'm inviting you so that we may make an offer. Start using these words. Yeah, in your conversations. Start using them. That was an invitation to treat. That was not a contract. They are so interesting. So, I was just inviting you to treat. Take an example of an invitation to treat. Displayed goods in the supermarket. Displayed goods in a supermarket with a price tag. That is not an offer. It is an invitation to treat. I'm inviting you so that we may make our contract. So, the moment you pick the goods from the shelves, you take them to the counter, the cashier desk, you pay. Then the contract is made. But if it is in the shelves or where they are put or in the window or where, that is an invitation to treat. I'm inviting you, come and we trade. Another example of an invitation to treat. I'm saying the last rule number 9, that it must be differentiated, offer must be differentiated from an invitation to treat. Another thing is about auction. Auction. At the fall of the hammer, the deal is done. So, in that way, it is not an offer. It is an invitation to treat. It is an invitation to trade. Before the fall of hammer, then it is not a contract at all. Let me give you this case. The case is Paine versus Cave. Paine is P-A-Y-N-E versus Cave or Cave. C-A-V-E. It is a 1789 case. What happened in this case? There was auctioning going on. So the defendant offered highest bid. It was giving a certain amount of money, but it was higher than the rest of the bidders. So, but thereafter, before the fall of the hammer, he said, no, I retract. I'm no longer interested. So this hammer guy or the company, the auctioneer company, went to courts of law. You know the whites. They went to courts of law. This company went to courts of law for breach of contract that he had offered, but then he retracted. So they went for breach of contract. The courts of law held that was an invitation to treat. The contract is made the moment the hammer falls down. So before the falling of the hammer, then it is not a contract. You invited persons to do the auctioning. So that is not a contract. The contract is not binding before the fall of the hammer. That was the holding in the case of Paine versus Cave. So yes, my students, those students who are following, actually who want to offer law, please, you are going to read these cases. You are going to read these cases. Read them. Make sure that you read the cases. You can only appreciate law course after reading the cases. Even these laws you cannot appreciate. Some of the words are ambiguous. Some of the words are very, very ambiguous. So after reading the cases, because as I said, the judiciary or the courts of law interpret the law for us. They interpret the law for us. So you can only appreciate law after reading the cases. So my friends, who I know are going to offer law soon hereafter and you are following, please read those cases. So, one, I said, displayed goods, it cannot amount to an offer. Like in the case of Fisher versus Bell, this is a locus classicus case that you need to read. Fisher versus Bell, it is a 1960 case, volume 3. Here we are going to write V. It is written like this. Fisher versus Bell, that is the party. You open brackets, you put 1960, close the bracket, you put 3. 3 stands for volume. The volume in which the case was reported, we have from volume 1, volume 2, volume 3, volume 4. Now, you put 3. It was reported in all England law reports. You don't write all reports. You put 3, you put capital A, and then double capital L. You put the page. The page in this case of Fisher versus Bell is 731. So you go to Mr. Google, you put in that case. For you who are going to be students, you need to put the old citation. That is called a citation. But for you who just want to get knowledge, you don't need to stress yourself. Just go to Google, put in Fisher versus Bell 1960. They are going to give you the case. You read it. You can read the summary of the case. You're going to appreciate the law. You're going to love the law. It is so good. So what happened in the case of Fisher versus Bell? In England, they had passed a law for prevention of arms. Thank you, Susan. That is it. One of the freak knife was one of the arms that the government was restraining to be used by the people. So this Bell he has his shop. He has displayed the freak knife. The freak knife. He has displayed it somewhere. So this police officer apprehended him that you are selling goods that are not accepted. This is an offer. So they went to courts of law. The plaintiff went to courts of law, and the courts of law, this was an invitation to treat, not an offer. He had just displayed the freak knife. It was not an offer, it was displayed. So the courts of law held that this is not an offer. It is an invitation to treat. So it was exonerated actually. Why? Because offer is different from an invitation to treat. So if I display certain thing, that is not an offer. I'm inviting customers. I'm inviting persons to buy. I'm inviting them. So if they come and buy, that is when the offer is made. That is when we are going to come up with a contract. That is another example of an invitation to treat. Another example number 3 is that one of a tender. If we advertise tenders, interested persons may come. It is not an offer. A tender, usually tenders, advertise tenders that we want you maybe to supply us with this and this and this. It is not an offer. It is an invitation to treat. So if you come, you expressly come, you are selected, the bid is done, you are selected, then that is when we shall have what we call an offer. So I've been differentiating an invitation to treat and offer, an invitation to trade, all an invitation so that we may come up with an offer, and then we do the contract which is binding, is differentiated from our offer. So if you go to supermarkets, or they have displayed their goods, or if you go to a drug shop, they have displayed their goods, the price tag is their own, That is not an offer, my friend. It is called an invitation to trade. We are inviting you so that we may trade, so that we may enter into a contract. Another thing is company prospectus. Company prospectus. You know, companies do issue prospectus, inviting the public to come and take up shares of a company. It happens in public companies. They come up with what we call a prospectus. It is an official document inviting the public to come and take up the shares. So that is not an offer. It is an invitation. They are inviting you. So if you come and they do not give you the shares, you cannot go to courts of law that there was an offer and then this company did not consider me. No. Why? Because it was an invitation to trade. They were inviting the public to trade. We call it treat. They were inviting you to trade. So if they do not offer you the shares, then do not go to courts of law. Do not waste your time. Why? Because it was an invitation to trade. We are inviting you so that we may trade. So if we do not trade, then do not take us to courts of law. That is the difference between an invitation to trade and offer. It is only offer that amounts to contract. And an invitation to treat does not amount. I want to move on to another thing is communication and communication of acceptance. I've already talked about communication of an offer, and I gave that case of Sinadaka. If you don't know about the offer and you do something, then do not go to courts of law claiming for the promise. Why? Because you never knew about the offer. You can only claim when the offer has been communicated to you. So that part is done. But then there is another part of the offeree. The offeree has to communicate acceptance to the offerer. So the general rule is that it is not, there can be no contract not until the offeree communicates acceptance to the offerer. So if you do not communicate acceptance and you just keep quiet, that means we can never have an offer. We can never have a contract. So that is the case of Fish versus Sinadaka. This guy apprehended a criminal, but US police had issued an advertisement that any person who apprehends this criminal is going to be awarded $200 US. But this person was ignorant of the advertisement, but then knew about this criminal somewhere, somehow. So he apprehended the criminal, took the same to police, but thereafter he heard of the advertisement that actually police had advertised this criminal, that any person who apprehends this criminal is going to be awarded $200. So they went to courts of law in the US. What happened? The courts of law held that if you do not know about the offer, then you cannot claim the promise. You cannot claim the promise. So that since this plaintiff never knew about the offer, they could not be awarded the $200. So communication is very, very important in contract law. Very, very important. And the general rule is that you have to communicate acceptance. So those who are going to offer law and those who are following, please read that case. It is very, very interesting. Another case that I want to discuss in line with acceptance from the offeree is the case of Fete House versus Bindley. It is, let me give you the spelling for those who are writing. It is F-E-T, then write house, versus Bindley, B-I-N-D-L-E-Y. It is 1863 case. Yeah, some of our cases are very, very, very old, centuries ago, but still the principles are applicable even up to now. So in that case, what happened? This uncle had a horse, but the horse was belonging to the nephew. So this uncle brought the horse for auction. But before he brought it, he wrote to the nephew that I want to sell this horse. If you do not reply, I'm going to presume that you've accepted my offer. So the uncle has the horse. He wants to sell the horse. He writes to the nephew through probably telegram, because there are the modes of communication by then. So that if you do not answer, or if you do not reply to me, I'm going to presume that you've allowed me to sell this horse. Yes, that is the spelling, Susan. So I'm going to presume that you've allowed me to sell this horse. So what happened? The nephew never replied. So this uncle took the horse for sale, for auction. It was sold. So the nephew brought the case that to courts of law, that I never allowed this uncle of mine to sell the horse. You are mistaken. The courts of law held that silence does not amount to acceptance. So if I gave you a proposal, let me give an example. This is a social example. If I gave you a proposal that, hey, will you marry me? And you keep quiet and you don't reply. Then I went on to organize for Sarah wedding, or say introduction. So anything, I go on. You cannot be liable. Why? Because you kept quiet. Silence does not amount to acceptance. But remember, in law, every general rule has what we call exceptions. So we have exceptions in law. But before I go to exceptions, how do I know that you've accepted? We have basically two. We have what we call instantaneous and non-instantaneous communication. Let me give an example. If I that, hey, I want you to sell me that car, and you replied, yes, I'm going to sell you that car maybe for $100,000. That is called an instantaneous, from the word instant. It is an instant reply. So in communication acceptance, we have two types. We have that instantaneous and non-instantaneous. So if say I texted you and your phone was off, say for a week, yes, that is called non-instantaneous. It is not instant. I may even text you, but you lost the phone. It was stolen. That is called non-instantaneous. It cannot amount to acceptance. And you need to first accept, you need to first communicate to me that I have accepted the offer. So, never do that mistake to presume that maybe silence has amounted to acceptance. No, never do it. So, I'm going to talk about the exceptions to that general rule, because in law we have what we call exceptions. Exception number one is waiver of acceptance. Waiver of acceptance. The offerer may waiver that acceptance. Remember, contract is between two persons, and the offerer is saying, no, I'm waiving that. Just perform. I'm waiving that. I'm waiving the acceptance bit of it. So if the same waive the acceptance bit of it, then acceptance is waived and there is offer. Another thing, unilateral contracts. What are unilateral contracts? I discussed unilateral contracts. Unilateral contracts are between these persons. So I'm offering a promise, and and you are going to do a certain act. That is called unilateral. So, let me give once again an example of a unilateral offer or a unilateral contract or a unilateral promise. Let me give that one over dog. I've lost my dog. So I advertise that anyone who finds my dog, I'm going to give them $100. That is called a unilateral contract. You don't need to write to me telling me that I'm going to look for that dog. No, you don't need to write to me that I'm going to look for it. No, I've offered to the public. But if you find my dog and you bring that dog to me, that means you've accepted. So the action, we have promise action. So if you do the action, that means you've accepted the offer. So that is called a unilateral contract. I offer promise, you do the action. You don't need to tell me that I'm going to look for that dog. No. If you find that dog, you bring it to me. And that is the case of Khalil versus Smokeball Company. It is the case of 1893 case. It is so interesting, and Locus Kilaskas case. Yes, you just need to read about this case. Because in that case, the offer was to the whole world. But then, if you did the conditions, you did the action, you bought that drug, and you contracted influenza, then you were supposed to be paid. Why? Because you acted upon the promise. So, we don't need acceptance. You don't need to write that I've accepted. No, why? Because it is a unilateral. Unlike the promise, you give me a promise. Will you marry me? Yes, I will marry you. So a promise to a promise. Will you do this? Yes, I'll do it. Will you sell me this car? Yes, I'll sell you this car. So it is promise to a promise. So that is an exception to the general rule of acceptance and communication. The last one is the postal rule. It was developed in the case of Adam versus Lindsay. You just need to read about this case. It is that one of Adam versus Lindsay. It is in the year 1818. And for law students, the citation is Volume 1, Queen's Bench, OQB, and ALD at page 681. I repeat for those who want to offer. The citation is 1818, close brackets, Volume 1, put 1, QB, and ALD at page 681. In this case, the postal rule was developed. What about the postal rule? The postal rule is to the effect that if you sent me an offer, the moment I send you back the post, that means acceptance has already occurred. Even if you've not received even if you've not yet received the post, the moment I post you back that I've accepted the offer, it means what? That I've accepted. So basically, we have 3 exceptions to the general rule of communication. Number 1, waiver by the offerer. The offerer, the person who offers the promise. Number 2, unilateral contracts. It is a promise versus an action. You don't need to communicate to me that I'm going to look for your dog or I'm going to use this drug. No, you don't need. And number 3, postal rule. And that postal rule is in the case of Adam versus Lindsay. It is a case of 1818. Lastly, I want to discuss termination of an offer. And if you have your act, it is in section 6 of the Contracts Act 2020. When an offer may be terminated, may be brought to an end, and we are saying that no, we no longer have an offer. The general rule to this still is that termination of an offer must be made to the offerer. Termination of an offer must be made to the offerer. That is the general rule. If you are no longer interested in this offer, then you need to communicate to me that I'm not going to buy your car. I'm not going to buy your car. And then, rule number 2, another rule for termination. Offerer may terminate the offer at any time. Like, if I'm selling my car, I may say, well, I wanted to sell this car, but I'm no longer interested in selling the same. I want to use it. Let me give it to my son. Let me give it to my papa or mama. So at any time before acceptance is done by the offeree, I can terminate before. Get this clearly, that offerer may terminate the offer before acceptance. But if you terminate after acceptance, I'm going to take you to courts of law for breach of contract. I think you can see how contract is very important. If you told me that you were selling me this bicycle or anything, and then I accepted the offer, and then you turned around and you told me that I'm no longer selling this, then I'm going to take you to courts of law for breach of contract. Why? Because I accepted the offer. So I'm going to take you for breach of contract, and they are going to give me damages. Why? Because you accepted. Those are rules. So section 6 has some things for what can amount to termination of offer. It talks about death and insanity. If I die, then I die. The law does not apply if I die. You cannot enforce it. If I had offered to give you something, but now I'm dead or I'm insane, I'm mentally incapable of performing the contract, then I cannot be liable. Then the offer is terminated due to either death or insanity. Then failure of a condition. It is another point. Failure of a condition. If I told you that, okay, like you are the offeree, I'm saying that this has this and this and this and this has to be done before this offer. If you do not do the conditions are put there for you, then the offer is terminated. At times, offers are conditional. Like the tenders, I've talked about the tenders. If you want certain qualifications and you do not have the qualifications but you've come, that terminates the offer. If I find out you do not have these conditions, the documents, you don't have these documents but you want them, you don't have these certifications but we want them, then an offer is terminated. Another thing, counter offer revokes offer. I explained counter offer, but for the sake of termination, counter offer is like this. I offered you my car the way it is, but then you told me, you know what you're going to do? I want a new steering. Work on these wipers or work on the tires. That is a counter offer. You've refused my offer and you want some modifications in the offer. If you want some modifications in the offer, and that means you are the offerer and now I'm the offeree, I may take up your offer or not. So any counter offer does what? It terminates the offer. Yes, I'm selling my land, but it is a chibanja. So you are telling me, hey, please, first go get the certificate of title for this land. Then I'll buy it. Then it is you who is offering. You've terminated my offer. You've terminated the area offer and you are offering. So it is incumbent upon me to either take up the offer or not. So I'm alluding to the fact that counter offer does terminate the offer. Another thing that can terminate the offer is called lapse of time. We can say we want teachers and the deadline is probably September 2020. After that deadline, then the offer is terminated. So if you come beyond the deadline, then you do not have any offer. Why? There is lapse of time. We said we want teachers, all doctors, all nurses in this specific period of time. But you came after that period of time. then the offer is terminated. We're going to read section 6 to appreciate that. But basically, that is it. That is what can terminate an offer. I want to thank you for listening to these law studies. Thank you very much. Maybe if you have any question, but I would like to end the session. God bless you.